Good afternoon, everybody. My name is Andy Zwerling. I'm here with my partner, Sal Puccio. Sal and I are partners at Garfunkel Wild, and it's our privilege and pleasure today to give the presentation of best practices for terminating an employment relationship. Just by way of, quick background about our firm, about Sal, about myself. Garfunkel Wild, we've been around now for over 45 years. We're a full-service healthcare law firm with approximately 90 attorneys in New York, New Jersey, Connecticut, Florida, and Washington, D.C. By full service, we run the gamut. It's a soup to nuts kind of law firm, healthcare, litigation, managed care, corporate, finance, mental health law, biotech, IP, and relevant to today's presentation, employment law. As far as Sal and I are concerned about our backgrounds, we have decades of experience as litigation attorneys, trial attorneys, and employment attorneys in terms of counseling clients on a day-to-day on how to navigate many different situations that can erupt precipitously, including what we're going to be talking about today, terminating employees. When we give these presentations, the dynamic's different if you're doing it in person. We can just call on someone in the audience. What I mean by that with regard to today is obviously we're doing it, through a webinar. And so we don't have that same ability just to tap on people in the audience. Sal and I don't like giving speeches, so consistent with that approach, you have the chat box. If you have any questions, just type them. We'll do our best to answer them in real time. If we can't, we can answer them afterwards and so on. So just, type out whatever questions you have, and we'll try and get to them, consistent with the presentation itself. As for, I guess we'll do it right here. Good morning. Will participants receive a copy of the PowerPoint? Yes, not a problem, but, that'll be at the back end. Hopefully you'll be listening to Sal and me throughout the presentation rather than just reading. So, count on that happening. As for the subject matter, many of you may already know or have experienced maybe many times, employees often face claims by former employees that their employment was terminated for an unlawful reason. And whether or not those claims have merit, a wrongful discharge claim can result in lengthy and expensive legal battles, adverse publicity, damaged morale in the workplace for those who are still showing up every day. And what Sal and I are hoping to accomplish today is to address certain key issues for you to consider when terminating an employee. We're going to provide what we feel are best practices to minimize claims or potential claims of wrongful discharge, and to enhance your ability to defend or respond to any claims of that type as they arise. So we're going to provide you today with guidelines on how to establish legitimate reasons for termination, how to assess potential legal risk, how to create and maintain relevant documents, including policies and performance reviews, how to deliver the termination message appropriately, and finally, how to protect your trade secrets and other legal and professional interests in the termination process. In terms of the context, just to emphasize, the parameters we're dealing with here, our presentation today assumes that the employee is an employee at will and is not subject to any rights created by a collective bargaining agreement, or is not part of a unionized workplace or public employment. So, with that foundation in place, we're going to move on to the subject matter itself.
Okay, thank you, Andy. And just as we get started, the perspective that we're coming from and what we really try to work on here at Garfunkel and our employment practices, helping employers and our clients avoid unnecessary legal challenges and, quite frankly, expenses. And what we found often is, I have a saying that I use with employers all the time: no employee gets terminated because they did anything bad. It's always the employer's fault. In other words, people have a very hard time taking responsibility for their own actions, whether it's performance-based or insubordination or something along those lines. By way of example, just an hour before this presentation, I got an email from a client, and we're working on some strategies toward regarding a termination issue, because the employee is going around saying, wait till they get the letter from my lawyer. They're going to see that I don't take being treated unkindly easily. And the person's already starting to make threats amongst coworkers about what she's going to do when the termination is effective, because we gave her a couple weeks notice to get things in order. So it's those kind of disputes that this presentation and our guidance generally is looked at avoiding. That said, as Andy said, we both come from a litigation background, and we've taken these cases to trial through discovery, settlement phases. You're not always going to be able to avoid a dispute with a disgruntled employee, but what you can do is you can be prepared for any potential claims or arguments, have your documentation in order, and be ready to fight against that employee. And by following some of these steps, we help to mitigate and limit any potential exposure or liability. So with that said, the first thing we look at is preparing for the termination. What should you be thinking about, and what factors should you consider? And we're going to go through many of those factors today. One thing to consider, is the person subject to any type of employment agreement? Is there an agreement that we have to counsel or look at to determine whether or not what the rights are for termination? For example, many of our clients in healthcare have employment agreements for their physician employees. So we would automatically fall back on looking at the terms and conditions of that agreement. And I'll talk more later about what to look for, but that's a starting point. Other considerations that I always ask, and Andy and our team ask, are there any complaints from the employee? Are there any disciplinary issues or discrimination complaints or retaliation complaints, whistleblower complaints that we need to consider and factor into our decision to terminate? Because oftentimes what happens is this manager says, well, I want to fire so-and-so, he's doing a bad job, but there may be an underlying complaint against that manager for race discrimination, let's say. So if you go ahead and fire the person, well, now you could have just added a retaliation claim to the mix from a legal perspective. Other considerations, is the employee currently on any type of accommodation? And sometimes staff members or managers even might not know the details or the extent of the accommodation. So when you're preparing for that termination, it's also important to consult with administration and human resources if your company has a human resources department. And again, if you don't, and you're concerned or wondering what you should do, contact us, because that's an opportunity for us to go through this checklist with you. The big considerations that you're going to have from a legal perspective are, what potential laws are there that are out there that could cause a problem for me with this termination? Well, what do I mean by that? Well, maybe the person hasn't been paid their wages, or they haven't been paid their wages on time. Or I had one recently where we were going to terminate someone, and I asked a bunch of questions about payout of PTO. And the employer wasn't familiar with the state and local laws where the employee was employed. And it turns out we had to guide them to say, you have to pay out the PTO. The termination notice the employer had prepared was, you forfeit your PTO. Well, they would have walked right into a state law, a wage and hour lawsuit that not only comes with paying the PTO, but then you're gonna have to pay for the person's attorney's fees and then pay us. So those type of considerations should be thought of initially. And then more of the broader context concerns to focus on would be, what's it gonna do to staffing? In other words, okay, let's terminate our billing manager. Well, who's gonna do the billing and collection for the next 30 to 60 days when we replace them? Do we have somebody lined up? Patient care is another one if you're in healthcare. Who is going to treat the patients, who is going to be able to meet the needs that we have within the office regarding this. And lastly, what is this termination, what effect, if any, might it have on staff morale around the office? So those are just kind of considerations to have when you're going to move forward with a termination of an employee. So I mentioned understanding applicable laws. Some of these are going to be apparent and you've probably heard of or understood or know already. But we'll just walk through a couple. But Title VII generally is that's a federal law that's going to generally protect individuals from unlawful discrimination in the workplace. It's going to protect individuals of a protected status, and that could include race, national origin, gender, sexual orientation, age, disability, etc. And it's going to go on. So you have to consider, has the person raised any complaints related to those protected categories? Is there a potential issue or concern regarding terminating this person because of a pending investigation related to a complaint? So that's one category. The American with Disabilities Act is another area where you'll have to determine whether or not the person has requested or is currently receiving some type of accommodation. A lot of times we get the question, and I had this one last week, so-and-so asked for an accommodation. They want to be out and work remote. We can't do the job remote. We're going to fire them. It's not that black and white, unfortunately, anymore. It's not that simple. We peeled back the layers and looked at the request for the accommodation, and the request came with a doctor's note that said so-and-so has stress and anxiety related to X, Y, and Z, and I recommend that they work from home because the office setting and the hostility between the employee and the manager is causing an exacerbation of the anxiety disorder. Well, if we just terminated that person's employment on the spot, it would have resulted likely in an ADA discrimination complaint or claim against us. So we looked at it, we worked through it, and you can ultimately reach termination if you go through the proper channels of determining the person cannot perform their essential job functions from home, right? If it's a nurse, for example, or a tech drawing blood, they can't do that remotely, so it's not going to work. And again, those other topics on discrimination and accommodations are covered in other topics. We're just issue spotting right now. Other laws to consider, FMLA, again, if an employee requests leave and wants to go out to take care of a family member or their own illness under potential state paid family leave laws like New York will have and New Jersey will have. If an employee is out related to the birth of a child, there are state laws that protect that as well. There are sick pay laws, wage and hour laws under the Fair Labor Standards Act and the New York Labor Law. All considerations that you should take into account when preparing for a termination and making sure the termination goes off smoothly and with all these considerations.
Just to piggyback what Sal said, when we're consulted on a termination, we don't look at the basis for termination in a vacuum in some silo. In other words, if the client calls up and says there are these performance issues A, B, and C, and that's grounds for termination. If they're an employee, I can fire them anyway. As Sal pointed out, we're going to look broader. Well, who created the performance evaluation or gave the negative feedback? Oh, is it a supervisor who is the subject of a complaint by that very employee? Do you implicate a whistleblower issue? Do you implicate a retaliation claim? The accommodation issues that Sal pointed out? Or even are there weak spots operationally if you terminate that specific employee? We had one particular case, there were grounds for termination, and then we discovered in our conversations with the client that the particular employee had been misclassified as exempt and should have been non-exempt, and it implicated overtime issues. And anybody who's ever dealt with a wage and hour claim knows how vulnerable that renders an employer. So when we look at these termination, cases, again, we view it through a broad lens, and we encourage you to do so as well. Consistent with that, develop and consistently apply policies. Proper documentation and implementation of one of your policies and procedures can be incredibly helpful in either avoiding a wrongful discharge claim entirely or defending against one if a lawsuit is brought. If you can point to a policy violation, whether it's a behavioral standards of any type, any policy, or written, guideline in terms of workplace conduct, it gives people like Sal and me a great boost because it's a pretty clear, visible line to discern, as a basis for termination beyond just, and we're going to get into some of the other types of documentation that can prove helpful, but a policy to point to would be great. Coupled with that, if you can have the acknowledgement by the employee that if they read it, that would be helpful. But so long as you can get some proof that they received it and had access to it, because we've all faced those situations where the employee doesn't sign the acknowledgement. Oh my God, what does it mean? It means that they didn't read it. Can I still use the policy as a basis for termination? The answer is yes, so long as they were given it, whether it's a hard copy or an electronic copy, whether they acknowledge it or sign the acknowledgement, you can still make use of it. But the deeper you can go, if you have a signature, the more compelling that proof will be. Now, policies, however, they're great to have and to point to during a litigation or in response to a pre-litigation demand, but only when they've been applied consistently We've gotten plenty of phone calls over the years. We want to terminate employee Smith because they violated the policy. You gave that webinar and said, if we can point to a policy violation, we're in good shape. And then Sal and I ask, okay, fine, the person's tardy. They show up 10 minutes late every day. We get it. Besides being an employee at will, that could be a grounds for termination according to policy. But with Jones, Johnson, and Smith, do you apply this to them? Well, no, right? Maybe because they're a better performer, maybe because they're more collegial, whatever the thing is. Policies are only useful if they're actually followed consistently, because some plaintiff's lawyer, understandably, is going to tap into the inconsistent enforcement to reinforce some claim that the true basis for the termination was some discriminatory or wrongful reason. Okay, so when you have these policy violations, enforce them consistently so you can call upon them when you need them. In the rare event you're going to have a termination situation.
All right, so as we mentioned, a couple specifics to get into. Consult any applicable employment agreement, and that's going to address concerns like, is there a for cause or without cause termination provision that needs to be met? By way of example, yesterday I was working with colleagues and the client to proceed with the termination, and there is an employment agreement. In this particular case, there's also a purchase agreement related to the purchase of this physician's practice, and there's multiple levels of documentary review that had to be done. And we went through it, and in looking at the for cause provision, there is a cure period. In other words, I'm going to terminate the individual, but before I can terminate the individual employment, I have to give them 30 days notice. Well, there were also provisions within that employment agreement that provided for immediate termination. So, in considering this issue with respect to the employment agreement, I want the audience members to consider it from two perspectives. One, which is the focus of today, that is, when I'm going to be terminating someone's employment, what should I be looking for in that employment agreement? And again, we're looking for things specific to the reasons for cause that might allow it, and some of them are pretty standard. For a physician, for example, if they lose their license or they're subject to a disciplinary matter that removes their ability to practice medicine in the state, death, disability, things like that. But then there are also more broad provisions that you look at where if the employee does something to harm the goodwill or benefit or name of the employer, that might be a reason. So, from the one perspective, what reasons are there that allow me to terminate this person either immediately, or what will I have to give notice to cure for? That's the first perspective. The second, and equally as important, but coming at it from a little bit of a different angle, is my employment agreement that I have consistent and strong and considering all these issues and factors? And what I mean by that is, about a year or so ago, we were asked to defend a claim from an employee complaining about discrimination upon termination. The termination grounds were solid. The employee had done some of the most despicable acts of sexual harassment in terms of sending pictures and images that we ever saw. And we terminated him right away. But he raised the question about being entitled to bonuses and other money and things like that. And the agreement was just silent with respect to those issues. So we had to read in different places. And I said, why don't we just make this clear? And let's add a provision: if you engage in any violation of company policy, protocol, practice, including without limitation, sexual harassment, discrimination, it's cause for immediate termination. That was something that we've now created for them going forward. Another common question that comes up with respect to consulting employment agreements is, well, what period of time do I have to continue to pay out the employee? If it's a salaried employee or an hourly employee and they happen to have a contract, you're going to pay them out through their last date worked, and you're going to be paid all accrued and earned wages. Where the more difficult question comes in is, what about if it's a physician who's receiving payment on an RVU basis or a net collection basis or something else, or there's reference to a bonus structure? And that agreement needs to be specific to say when the wages are earned, when they are paid, and what happens in terms of what I term a tail collection perspective. So those are things to look for. Other quick points to mention with respect to consulting the employment agreement: is there a restrictive covenant or non-solicitation provisions that's applicable? If so, what we like to do is, in our termination notice, remind the provider, remind the employee by the way, you have to keep it confidential, our information, not solicit our employees and patients or customers, and you're restricted in the following ways. And then lastly, is there an arbitration provision? And you should be aware of that in case the claim goes any further.
Okay, document the reasons for termination. This is a big one. It should be self-evident that if you're going to document someone and they're going to accuse you of terminate somebody, and then they accuse you of some wrongful basis for the termination, and you're saying, well, it was related to performance issues, that you're going to have some paper support for that position. When Sal and I and our team get the phone calls, we want to terminate somebody, or they get a pre-litigation demand saying there was a wrongful termination, the first thing we ask you is, give us the documentation. And too often we get we had telephone calls, or we had meetings and we spoke, right? And I'm not saying anything, anybody over the age of 12 doesn't know that people forget conversations, or they heard it differently, or they recall differently. And so you need to have some documentation to substantiate your position that there was a proper basis or for termination, or a basis rooted in performance issues. And so if you can have written performance evaluations discussing the performance flaws, minutes of management meetings at which the terminated employee was discussed, or soon to be terminated employee was discussed, disciplinary or poor attendance records, even emails. If you have emails from a supervisor to the subordinate who is getting terminated or was terminated saying, so-and-so, late again, so-and-so, untimely inputting of information, whatever the problem is, even those simple emails will arm us in a very compelling way when we say that the basis for the termination was performance-based. Now, we've had those situations where there has been no documentation up to the phone call to us. It's never too late to start documenting. We've had those situations. We'll say, okay, you haven't documented the last 6 months of issues. You want to give the person another shot to improve. So what you do is document now what the historic 6 month worth of issues has been. Sit down, talk to the employee, walk through the specific issues of the last 6 months, then document that you met with the employee and discuss those issues. It's always better if you have real-time documentation, but that is very helpful as well. And so never say to yourself, well, I didn't document before, what's the point of starting now? I'm going to be accused of it being pretextual, or I made it up just to compensate for the fact that it really didn't happen, and so on. Again, start the documentation as soon as you realize that you have not. A critical specific point about documentation, we have had several cases in which the employer properly and helpfully documented the intent to terminate the employee before the termination discussion was even had. And at least 3 litigations where that documentation led to successful outcomes without a trial. In one specific instance, the employer had documented the intention to call, there was a Friday morning, to call the employee in on Monday for a termination. Somehow the employee got wind of it over the weekend, and I kid you not, Saturday night, the email comes in from the employee with FMLA documentation, a note from a doctor saying that the employee had to go out on disability. That employee was fired on Monday. Why? Because it was already documented on Friday morning, the intent to terminate. So it eliminated any possibility of a retaliation claim. We had multiple pregnancy discrimination cases where before the employee said that she was pregnant, there was documentation, clear, well drafted, very simple. You don't have to write books saying we're going to fire so-and-so based upon all of these performance issues. And when the decision makers wrote that, they had no clue that the employee was pregnant. So when the employee showed up at the termination meeting and said, by the way, I'm pregnant, it allowed the employer to defend itself successfully against a claim of retaliation or pregnancy discrimination. So if you intend to terminate, Document the intention even before the actual act. So a few points about documenting the predicates for termination and how a failure to document properly may undermine the basis for your termination. Be careful about how you write things. Use, an objective tone. Stick to facts, okay? Be objective, be professional in your choice of language. And the example Sal and I give, they're all rooted in cases we've handled. For example, don't write employee is too old to grasp new technology. Not helpful to your position, okay? Avoid personal comments, avoid overstatements in the documentation concerning the reason for termination. Emotionally charged language, speculation or assumptions. Stick to facts, and in particular, if you can, facts supported by documentation. The more your documentation is flawed or mistake riddled, the less it's going to serve the purpose that you intended it to serve, which is to support your credible claim of a proper basis for termination. Give honest criticism, but don't go over the top, all right? We recognize supervisors are reluctant to give, honest, blunt criticism in person or even in writing, but it's necessary. It has to be done. And again, it can be done succinctly. You don't have to write too much in order for Sal and I to be on accordingly. All right. With regard to documentation, train your supervisors on how to document. Don't assume, a lot of times a person gets promoted to the supervisory title because they can handle the job well. It doesn't mean that they are qualified yet or ready yet to be a capable supervisor. And train them on how to document performance, train them on how to speak to their subordinates and so on. Most people are not born with skill in this area, so to avoid what are avoidable issues, make sure they're trained in some respect to handle the review function or have a trained person with them along with the documentation component of this.
All right, so as we follow up on the documentation, and as Andy said, that's probably one of the most important things you can take away from this presentation, because that'll help guide you in a lot of ways if you're properly documenting things. And following up from that, what termination protocols can you put in place or should you do? As Andy said, with respect to documentation, that's certainly one of them. And within that is, and Andy gave some great examples, document somewhere the intention to move forward to termination and try to do it as quickly as possible. Now, that said, I understand when you're balancing scheduling, staffing, patient needs, customer needs, et cetera, you have to put a plan in place and say, okay, we're going to terminate so-and-so next Friday because of all these factors. In that interim, keep it to a need-to-know basis. In other words, don't start going out and letting everybody know or certain people not within a very close circle know that the termination is coming. That's for a couple of reasons. One, the person could come forward with a trumped up or pretextual disability claim, discrimination claim, or they might just start not showing up to work or sabotaging your business in other ways. So you're trying to keep it within a close group. Another protocol we like to follow, again, if you have HR or there's an administrator in your office or an owner or an operator who really is in charge of these final decisions, make sure they are involved, because that person or persons may know of other issues or reasons why the termination should not happen or why it should not happen at the present time, including disability issues, personal family issues involving the employee, or other reasons. Setting up a meeting, well, again, if HR is involved, let HR take the lead in that. Schedule a meeting. Try to have a witness present, just counseling someone for a termination that's going to happen next Tuesday. We've documented it internally. A termination planned for Tuesday based upon these reasons. And it's delayed a week because of the staffing issues I mentioned. But we're going to have a team of people meet for that termination, including someone from HR who is going to have the relevant information, hand them a termination notice. That's another thing. At termination, you have to provide in writing that the person is terminated. We don't like to get bogged down in all the details and minutia of why they're terminated. If it's a for-cause reason that's required under an employment agreement, we'll say for cause. Sometimes we'll say pursuant to section X, Y, and Z. It might be for insubordination, lateness, etc. You can give some reason, you don't always have to give a reason. That'll depend on the circumstances of the case. And lastly, a couple of considerations to keep in mind with respect to protocols. Final wages, when should they be paid? Again, you put in that cover letter, New York, New Jersey, for example, is within the next regularly scheduled pay period. Connecticut, however, is the next day. So now you're going to have to contact your payroll company and say, cut a check to Sal, we're firing him tomorrow. He's got to get paid immediately. And then the last consideration we'll talk about a little bit more at the end is, from a protocol standpoint, are there any security measures or procedures we need to put in place with respect to termination of a particular employee? And Andy and I have seen that, where an employee is going to become disruptive and yell and scream and want to take everything with them. But you should have a policy in place that you're protected, that you're going to get back the laptop that you might have, the keys, the fob, the card, whatever it is to get in, all part of your protocols at the end to separate from that employee as peacefully as possible. Next topic, gather and assess relevant information. Again, this kind of goes back to leading into what we're going to need for that termination. We'll kind of cover this one quickly because we've touched on it, I think, pretty sufficiently already. But again, have that employment agreement available and ready. Have any performance reviews, notices, complaints, investigations that might have been done pertaining to this employee. Any performance improvement plans that were put together. Any disciplinary notices that were given, and the history of what information you have regarding the termination. That's going to be useful for two reasons. One, if the employee were to ask questions or question the basis for the termination, you'll be armed with some information and documents that you can refer to, so it's not like you're just going off the top of your head. You don't have to provide that information to the employee at the time of the termination. You don't even have to have it with you in the room, but just have it gathered and put in a folder so you do have it. And the second reason for gathering the relevant information is if the employee were to become disgruntled or hostile after leaving and they want to file a claim or a lawsuit, instead of having to go piece everything together and scramble and put things together, you have everything in a nice, neat package. And if you're also going to be consulting with your HR team and or your attorneys, we'll have everything collectively together so we can make an informed decision. One step to do early on to avoid waste later.
All right, best practices for delivering the termination message. To effectively communicate an employment termination message, the message itself should be documented and carefully worded. As I mentioned before, with regard to documentation and training your supervisors, don't assume that someone who's a supervisor, if they're going to be involved in the termination itself, knows how to conduct one. So train those who are going to deliver that message so they can handle it properly and avoid problems that may arise if it's handled poorly. One, time the decision to allow for privacy. Pick a time either before the workday starts or after the workday ends, when there's going to be as few interruptions as possible, and choose a private meeting place. Location out of view, that's, I'm not saying off site, it's going to be on site in most of the circumstances, where you're not going to have people walking in and out and, interrupting and disrupting, a pretty difficult conversation. Prepare and rehearse the delivery of the message. We're not saying that you have to spend hours doing so, but don't wing it. Don't just walk in and just throw some words out, because keep in mind, while you as the employer may say, well, there's a reason for terminating the employee, they're just not the report performer, whatever the proper reasons are for that justify your decision, you're about to turn someone's world upside down. You're about to impede their ability to pay the rent this month or put food on their table. It's going to be an emotionally charged interaction. So walk in prepared, and again, if possible, just play it out in your head. How are you going to deliver it? If you're going to do it with two people, who's going to say what? Is one person going to write point? Are you both going to talk? Work that out ahead of time. And if you want a little cheat sheet with a couple of bullet points, that's fine too. You're not going to share it with the individual, but just to help you organize your thoughts before you enter the room. Have a witness, because we have those situations where a former employee who's filed a lawsuit is claiming that you, as the supervisor who terminated them, said things that, indicated discrimination or whatnot. Have a second person in the room. So you have somebody to substantiate your claim about what was actually said. Be direct in sharing whatever it is you're going to share about the basis for the termination. Make the necessary points, without making excuses, without minimizing the reason for the decision. Avoid personal attacks or derogatory statements. Make sure that you're speaking in a clear fashion. It could be a very simple fashion, but be clear about the basis. Avoid arguments. Don't enter in arguments if they push back and say, or try to point to a specific instance to show that they did right or they didn't do wrong. It's not a debate, right? You don't want to inflame the situation. You already made your decision as an entity, as an employer, and you've already given the basis for the decision. If the person wants to vent, that's fine, but you don't have to go back and forth. And again, be prepared for negative response. As Sal said earlier, we've never heard of an instance where someone's terminated and they go, you're right. I'm just terrible at this job. How did you keep me so long, right? Never going to happen. They're going to push back typically. Some will be silent and walk out. Some can get, pretty vocal, if not violent, from time to time. But don't expect anything other than a negative response. Don't interject personal statements. Be sensitive to the employee's anger, but don't agree that the employer has made any mistake or acted inappropriately. Don't use, and we've had these, you're the one delivering the termination message. You go, well, look, this isn't my decision, right? You're pushing someone else in front of a bus and saying or implying that maybe you don't agree with it, or I would not have fired you if the decision had been up to me, okay? It will not go well for you. It will not go well for the employee as well, because you're not being honest at the end of the day, all right? You'll give an outline of the status of available employee benefits, as Sal pointed out earlier. You can discuss references. Typically, it's just that, title and dates of employment and so on. And be sensitive. Again, termination is a difficult and emotional matter. So, keep yourself contained regardless of how antagonistic or inflammatory the employee may be. Document the termination. This one's not deep. Create a written record of why, how, and under what circumstances the employee was terminated, right? And again, you don't have to be fleshy and write pages and so on. But, give the underpinnings for the termination, the reasons why, how the termination was done. Sal Puccio and Andy Zwerling met with employee Smith to discuss the termination and explain that the reason for the termination was A, B, and C. Again, simple is fine.
So just some additional considerations, and in particular, on a healthcare side, if you're a healthcare employer, there's protecting personal health information. And for our clients that are non-healthcare, there's also protecting just general sensitive information or personal identifiable information that you might have. So when you are going forward to termination, things we look to do, a lot of protocols have to be taken with respect to PHI, for example, personal health information. Do you have protocols in place in order to wipe a person's laptop or computer? Right. The first step is let's get back that computer. But in today's day and age, people might be living out of state, out of county, working remote. And how do you access that information so that you can either get it back, the laptop or whatever it may be, or wipe it clean? I had a situation, non-healthcare, where an employee was terminated. Took steps to get back the laptop. The person worked home, worked remote, and actually brought her laptop to her new employer. And then they started going in and downloading customer lists, proprietary information, documents, and things like that. Now, luckily, this client was sophisticated enough that they had certain firewalls in place, and they weren't really able to access that information. And when we questioned the employee and we had to sue her for breach of her terms of employment relating specifically to sharing trade secret and customer information, the defense was, I was just having a hard time getting my personal emails off there. Okay, well, you know what? Come to us. We could have helped you with that, but we had to sue that employee and the new future employer to demonstrate that we were not going to allow that. So have protocols in place and understand you want to get back this information as quickly as possible, and protecting your lists and other information that sensitive information that you have. One other additional consideration, not necessarily related to protecting sensitive information, but sometimes you terminate from an employee and they might be subject to a loan agreement or an agreement, a tuition reimbursement agreement. Keep that in mind as well, because there might need to be steps taken to notify the employee that you're going to be calling that loan or the payment back of that tuition reimbursement.
Just a few more on protecting sensitive information, just a couple of bullet points. If you're terminating somebody, disable their access to your system. We've had instances where people have gone in and deleted or damaged files and so on, or simply stolen information. So disable their access right away, collect any property they may have. Again, you don't have to engage in a tug of war to do that. And also, depending upon the situation, you may or may not want to escort the person out. There are certain situations where it would be wrong-minded to do so, create an unnecessary negative image if you're walking somebody out who doesn't need to be escorted, where they are someone you can trust and so on, to not act out. But you are going to get those situations where escorting them out is the right thing, where you don't have someone who's just terminated walking around, creating problems or creating a toxic environment. So, keep those, factors in the forefront of your mind once you have that termination meeting.
Okay, on to waiver and release agreements. Now, as a starting point, these waiver and release agreements can be an absolutely powerful tool in terms of bringing closure to a matter, getting a release from staff members, and in particular when there's a potential issue or dispute regarding the status of someone's employment. That's particularly helpful to have, again, like that closure that you can resolve. Now, we go back and forth. Sometimes clients want to say, well, I don't want to create a precedent. That's okay. Take these cases situation by situation, and determine, is it relevant in this particular matter? Usually what we do is we just say, for your years of service or months of service, or because we feel for you in this particular time, we're going to offer you 2 weeks severance in exchange for you signing this separation agreement. And it's a simple letter. It's cost effective. It's a really great tool to use, especially if there are some of those questions or concerns that you may have. It addresses and deals with all issues and could protect you significantly in the long run, to avoid any particular claims. So, again, I think waiver and release agreements, they're standard. It's not as uncommon as it used to be, where people were admitting a form of liability. We're not going to admit any liability. We're just going to deal with it, get it done, have a sum certain, and move forward. Anything else you want to add on that?
No, I think we're good.
All right. So we covered these topics. If there are any questions or follow-up, again, the chat box is open and available. But also we would be available for follow-up questions and comments that you may have. So we'll keep the box open for a minute. Otherwise, we thank you all for your time today. And we look forward to hearing from you in the future. And just as a last point, keep on the lookout for additional updates. We have an employment series that's going on with additional programs as well. I don't know if it's exactly monthly or quarterly, but they will be frequent, and we know we have them coming up throughout the summer and into the fall already scheduled.
Absolutely. Thank you, everybody.
One question.
We got a couple of questions. All right. Must we explicitly tell employees why we are ending employment? All right, the questions are coming. That's a good thing. The short answer is that you don't have to be detailed and so on. You can be, you can speak in a pretty generalized way. You can keep it as simple as performance issues that we discussed with you over a period of time. You can say, I'm just using made-up examples in the moment now. It could be performance issues that we discussed with you over time, including showing up late, insubordination. Again, you can speak in terms of categories. We suggest less is more, because you want to avoid any possibility of inadvertent inconsistencies between what you may say in a termination meeting and what may be the reality. Again, these conversations can be emotionally charged, and you want to try and keep it as simple as possible during that interaction. Anything you want to add on that one, Sal?
No, the only thing I would say is, not to kind of sideswipe, but it's a case-by-case basis. In other words, If you've had a long history with the employee and they've been problematic and they've raised complaints, we'll probably want to be a little bit more detailed. If it's going to be someone who's a high earner and there are some expected disputes that you have coming, we might want to provide at least some specifics that we're terminating you for cause and in response to you, competing against us in violation of your restrictive covenant, some kind of language like that. So you'd have to evaluate the circumstance of each situation.
Is it required to have an employee sign a termination? No. Quite frankly, I'm not sure how you get the pen in their hand and their signature on any document, but it's not required. You want to take
what was it? I can't read it, sorry.
Must you pay termed employees immediately or in the next regular payroll?
So that's going to depend on state law where you are. The ones we covered in New York or New Jersey, it's going to be the next payroll period. In Connecticut, it's going to be immediately by the end of the next day. So again, factor to keep in mind when preparing for the termination and knowing what you're going to have to do going forward. And then there might also be some contractual requirements in terms of what PTO you have to pay out, if any. And that's going to depend on what your written policy is. And again, that goes state by state. So part of it depends on where you are, but generally it's got to be the next payroll or the next day.
Another question, must we send a certified letter to termed employees we cannot reach? Well, one, the question kind of answers itself in the sense if you can't reach an employee, then they haven't been showing up. So in some ways, the justification for termination becomes even stronger. When you terminate somebody, there's certain requirements. I'm only speaking about New York, for example, and again, each jurisdiction may be different. You need to provide a record of employment form to the terminated employee so they can apply for unemployment benefits. So you're going to send a writing out in the normal course. It doesn't necessarily have to be by certified letter. There's a presumption of mailing that it was received if you just put it in first class mail. But you can do email if you have their personal email address and their home address, send it out that way. You're going to memorialize it in some fashion, but it doesn't have to be by certified letter. I think we're good.
All right.
Thanks, everybody. It's been our pleasure.
Thank you, everyone.